Namaskar. Good morning, brothers and sisters, ladies and gentlemen, students and scholars, teachers, trainers, professors, professionals, officials, listener, learners. I welcome all respected doctors and directors. I welcome honorable ministry managers. I welcome adorable advocates, advertiser, administrative advisors. I welcome the most honorable President Prime Minister Modi ji. It is really nice time, nice place, nice section today that we are defining, expressing, explaining our holy Indian spiritual, social, cultural identities, features, its characteristics in the form of unity and diversity. We pray to God for the peace of mind and tranquility of heart. Universally, globally, our holy Indian spiritual identities claim that we are the generator, starter, creator in establishing peace in the world. Politically, economically, socially, spiritually, intellectually, emotionally, from every aspect of life, our India is known as the nation of freedom fighters, free thinkers all over the world. Our India is known by its country of the leaders. Not only politically, but in establishing spiritual values, human values. It has its own importance for the worldly people. Whenever, whenever worldly people, worldly leaders are deflected from their path, then India shows them the path of peace of mind and tranquility of heart. Nature is the common concept of all our holy religions of this holy land. All romantic poets, nature poets appreciates nature, admires nature, praises nature in the form of welfare of humanity. What is written in the international law? Let us go through today. Alarming our military preparation, alarming military preparations by a neighboring state would not justify resort to anticipatory force by the state which believed itself threatened. It has been rightly remarked the principal lesson of the League experience and two World Wars is that the plea of self defense should be held within strict confines so that states may be precluded from embarking upon aggressive wars in the name of self defense. The Charter of the United Nations has rightly restricted self defense to armed attack. The solemn words of the preamble of the UN Charter that the scourge of war, which twice in our lifetime has brought untold sorrow to mankind, warn against an interpretation of the Charter which extends the scope of self defense beyond the limits of Article 51 in case concerning military paramilitary activities in and against Nicaragua. Nicaragua versus United States of America. The International Court of Justice held that the right of collective self defense presupposes that an armed attack had occurred. Further, under international law in force today, whether customary international law or that of the United Nations system, states do not have a right of collective armed response to acts which do not constitute an armed attack. As regards the definition of an armed attack, the word court observed an armed attack must be understood as including not merely action by regular armed forces across an international border, but also the sending by or on behalf of a state of armed bands, groups, irregulars, or mercenaries which carry out acts of armed force against another state of such gravity as to amount an actual armed attack or its substantial involvement therein. Distinction between self defense and self preservation. A few words will not be out of place here to explain the distinction between self defense and self preservation. Under the traditional or general international law, there was hardly any distinction between the two terms. However, it must be noted that the term self-preservation is much wider than the term self-defense. Under the traditional international law, intervention on the ground of self-preservation was permitted. Even military preparation in the neighboring state could justify intervention in the affair of that state. The Charter of the UN does not at all mention the term self preservation. The Charter recognizes retaliatory measures or use of force only on the ground of self defense as compared to self preservation. Right of self defense is a very much restricted right and can be exercised only when an armed attack occurs. Other conditions mentioned in Article 51, as explained earlier, must also be fulfilled. लगभग 2.25 करोड़ खरीफ सीजन के लिए पोषक तत्व आधारित सब्सिडी को मंजूरी। बंगाल का चुनावी श्योर। कैबिनेट ने जयपुर मेट्रो प्रोजेक्ट फेज 2 को दी मंजूरी। धमकी बमर बंदूक क्या यही है टीएमसी की चुनावी हुकूमत का रूप? असम के पुदुचेरी में वोटिंग आज, एक चरण में मतदान। अब की बार हाथ पैर तोड़ने की तैयारी। टीएमसी महासचिव अभिषेक बनर्जी का इस बयान। विदेश मंत्री डॉक्टर जयशंकर विदेश मंत्री मॉरिशस में हिंद महासागर सम्मेलन में होंगे शामिल। पश्चिमी बंगाल में आज पीएम मोदी की 3 जनसभाएं। कभी दीदी कभी दादी। बंगाल में जुबानी वार, कभी चुनाव आयोग तो कभी भाजपा पर प्रहार। लगभग 2.25 लाख करोड़ रुपए के मेगा प्रोजेक्ट्स को हरी झंडी। खरीफ सीजन के लिए पोषक तत्व आधारित सब्सिडी को मंजूरी। रक्त रंजित इतिहास धमकी बम का साथ क्या लोकतंत्र फिर बेबस। आज कैबिनेट ने जयपुर मेट्रो प्रोजेक्ट फेज 2 को दी मंजूरी। असम के पुदुचेरी में 296 विधानसभा सीटों पर एक ही चरण में मतदान। अब की बार टीएमसी महासचिव अभिषेक बनर्जी का इस बयान। विदेश मंत्री डॉक्टर जयशंकर आज से मॉरिशस और यूएई के 4 दिन दौरे पर। विदेश मंत्री मॉरिशस में हिंद महासागर सम्मेलन में शामिल होंगे। पश्चिम बंगाल में आज पीएम मोदी की 3 जनसभाएं। पीएम की अध्यक्षता में हुई कैबिनेट बैठक के लिए 5 लगभग 2.25 लाख करोड़ रुपए के मेगा प्रोजेक्ट्स को हरी झंडी। खरीफ सीजन के लिए पोषक तत्व आधारित कैबिनेट ने जयपुर मेट्रो प्रोजेक्ट फेज 2 को दी मंजूरी। असम, केरल, पुदुचेरी की 296 विधानसभा सीटों पर थोड़ी देर में वोट आज। असम, केरल, पुदुचेरी में एक ही चरण में मतदान। विदेश मंत्री डॉक्टर जयशंकर आज से मॉरिशस और AEI के दौरे पर। विदेश मंत्री मॉरिशस में हिंद महासागर सम्मेलन में शामिल होंगे। पश्चिम बंगाल में आज PM मोदी की 3 जनसभाएं। PM की अध्यक्षता में हुई कैबिनेट बैठक में लिए गए 5 बड़े फैसले। लगभग 2.25 लाख करोड़ रुपए के मेगा प्रोजेक्ट्स को हरी झंडी। खरीफ सीजन के लिए पोषक तत्व आधारित सब्सिडी को मंजूरी। कैबिनेट ने जयपुर मेट्रो प्रोजेक्ट्स फेज 2 को दी मंजूरी। असम, केरल, पुदुचेरी की 296 विधानसभा सीटों पर थोड़ी देर में वोटिंग। असम, केरल, पुदुचेरी में एक ही चरण में मतदान। विदेश मंत्री डॉक्टर जयशंकर आज से मॉरिशस और UAE के दौरे पर। विदेश मंत्री मॉरिशस में हिंद महासागर सम्मेलन में शामिल होंगे। पश्चिम बंगाल में आज PM मोदी की 3 जनसभाएं। PM की अध्यक्षता में हुई कैबिनेट बैठक में लिए गए 5 बड़े फैसले। लगभग 2.25 लाख करोड़ रुपए के मेगा प्रोजेक्ट्स को हरी झंडी। खरीफ सीजन के लिए पोषक तत्व आधारित सब्सिडी को मंजूरी। कैबिनेट ने जयपुर मेट्रो प्रोजेक्ट्स फेज 2 को दी मंजूरी। असम, केरल, पुदुचेरी की 296 विधानसभा सीटों पर चुनाव आज। असम, केरल, पुदुचेरी में एक ही चरण में मतदान। डिस्टिंक्शन बिटवीन सेल्फ डिफेंस एंड सेल्फ हेल्प। It's sometimes said international law in its technical aspect is a primitive law functioning in a society yet in an embryonic state and characterized by technique of self-help. This view does not seem to correct. This view does not seem to be correct. The traditional or general international law recognized the right of self-help in many situations. The Charter of the UN has greatly restricted this right. The Charter confers on each state the right of the individual and collective self-defense in case an armed attack occurs. Thus, in case of an armed attack, even the Charter recognizes the right of self-help, but this right recognized under the Charter is subject to several restrictions as pointed out earlier, including the review by the Security Council. The right recognized under the Charter is thus distinct from that of self-help and is therefore, and rightly too, referred as the right of self-defense. As remarked by Gerald Fitzmaurice, the Charter frowns on self-help. It goes far towards rendering unenforceable by direct action the whole of international law except the breach of peace. Article 2.4 of the Charter provides that all members shall refrain in their international relation from the threat or use of force against the territorial integrity or political independence of any state or in any other manner inconsistent with the purposes of the United Nations. Moreover, it is one of the purposes of the UN to maintain international peace and security, and to that end to take effective collective measures for the prevention and removal of threats to the peace and for the suppression of acts of aggression or other breaches of the peace, and to bring about the peaceful means and in conformity with the principles of justice and international law, adjustment or settlement of international disputes or situations which might lead to a breach of peace. The Charter, however, recognizes the right of individual and collective self-defense if an armed attack occurs. But even this right, which may to some extent be called the recognition of the right of self-help, is subject to the review and control of the Security Council, which, as Article 24 provides, has the primary responsibility for the maintenance of international peace and security and acts on behalf of the members of the UN. Thus, there is a difference between self-defense and self-help. Self-help is a right which existed in the primitive legal order in an advanced international legal order. It is prohibited so long international law was a primitive legal order. There was provision for self-help in the form of war and reprisal. On the contrary, self-defense is based on the illegality of war. As aptly pointed out by Joseph L. Kuhn, self-defense as a truly judicial institution presupposes an advanced legal order, and international self-defense is therefore closely bound up with a more advanced international organization. As pointed out earlier, Article 51 of the UN Charter, which provides the right of self-defense, also provides for its limitation. Moreover, it is subject to the control of the Security Council. Intervention on humanitarian ground. Intervention was permitted in past on humanitarian grounds. After coming into force of United Nations Charter, the United Nations has done commendable work in the field of human rights. If at all intervention is permitted on humanitarian grounds, it may be done only by the United Nations on the basis of Article 155 and 56. It may be said that Charter provisions relating to human rights create legal obligation upon the members in respect of human rights. But the Charter does not authorize any state to intervene in the affairs of another state. This is clear from Article 2.4. Even UN has been prohibited under Article 2.7 from intervening in the domestic affairs of member state. Consequently, on the ground of human rights alone, even the UN cannot intervene in the affairs of any member state. It can, however, do so by connecting or linking the matter of human rights with that of the maintenance of international peace and security. That is to say, if under Article 39 the Security Council determines that violation of human rights in any state poses a threat to peace or amounts to breach of peace, then the Security Council may intervene, for then the provision of Charter 7 of Charter become applicable. The glaring example of this is recent intervention by the UN in Iraq on behalf of Kurdish people. To enforce, treat, to enforce treaty rights, intervention was also permitted in past under international law to enforce treaty rights. The Charter of the UN does not permit intervention on this ground. Intervention to prevent illegal intervention. In the past, in past there have been several cases of intervention by states in order to prevent illegal intervention by other states. Intervention by one state in the affairs of another state on this ground is no more permissible. Balance of power. In past there have been many cases of intervention in order to maintain balance of power under the United Nations Charter. This is not at all valid ground. Thus, no state can intervene in the internal or external affairs of another state in order to maintain the balance of power. As a matter of fact, international law today tends to convert the system of balance of power into a system of collective security. The system of balance of power has been replaced by a system of collective security. Though intervention by a state or UN in the domestic affairs of a state on the ground of balance of power is not more permissible, politically reference this ground is still not uncommon. A major nuclear confirmation between the two superpowers, the US and the USSR, has so far been avoided on the basis of balance of powers in respect of nuclear weapons. It would not be wrong to say that in all talks of disarmor, disarmament between the two superpowers, balance of power forms the basis directly or indirectly. Besides, whenever India protests against US supply of dangerous weapons to Pakistan, reference of the disturbance of balance of power in the subcontinent is made. For protection of persons and property, in past international law permitted intervention by a state for protection of the person and property on its citizens. This ground is no more permissible under the Charter of the UN. Collective intervention or collective measures. Under the UN Charter, collective intervention can be made to check an aggression on the breach of international peace and security. Under Chapter 7, Security Council has been empowered to take collective action. If there exists a threat or a breach of international peace and security, or an aggression has taken place in the first stage, the Security Council takes such collective measures as do not involve the use of force, but if such an action does not prove to be adequate, the Security Council is empowered to employ armed forces. The United Nations took such action by Korea 1950 and in Congo 1961. The recent example of such action is Gulf War 1991 for the occasion of Iraqi aggression and occupation of Kuwait. This has been discussed in detail in chapter on the Security Council. Intervention to maintain international law before the establishment of League of Nations and United Nations. International law permitted intervention for maintenance of international law. International law intervention on this ground is no more permissible. Intervention in civil wars in view of the continuous growth of international community. Nations of the world have established close relations with each other. If anything happens in a state, it is quite natural that it makes its effect on other states as well. If there is a civil war in a state, it is likely to affect directly or indirectly other states. In past, there have been interventions by states in affairs of other states on this ground. For example, in 1934 to 38, Germany and Italy intervened in the War of Spain. In 1968, Russia intervened in the civil war of Czechoslovakia. Similarly, Russia intervened in the affairs of Hungary. The question arises how far such type of intervention is justified in a view of the fact that the United Nations Charter has propounded the principle of non-intervention by states in the affairs of other states. Jurists are of the view that Russian interventions in Czechoslovakia and Hungary were not justified, but Russia claimed that it intervened in the affairs of Czechoslovakia and Hungary on the request of their responsive governments. It has been suggested that in civil war, the United Nations should have the right to intervene. The United Nations should take necessary action to check such type of war. Professor R.P. Dokalia has pointed out that a successful example of intervention by United Nations in the case of Congo in 1961. In Congo, United Nations succeeded in ending the civil war and in establishment of law and order. It may be noted here that the UN can intervene in civil war only if the Security Council first determines under Article 39 of the Charter that it poses a threat to the peace, breach of peace, or amounts to an act of aggression. If the Security Council makes this determination, provisions of Chapter 7 of the Charter becomes applicable. The recent example The recent examples of such intervention by the UN Security Council are intervention in Iraq on behalf of the Kurdish people and intervention of civil war of Yugoslavia and Somalia. In its conclusion, we can say, in view of this discussion, it may be concluded that a state may intervene in the affairs of another state only on the ground of self defense. The UN may intervene in the domestic affairs of member states on the ground of maintenance or restoration of international peace and security. That is to say, it can take collective measures or can take collective intervention if an aggression has taken place or there is a threat to international peace and security. The UN may also intervene in case of civil wars between two member states or in case of violation of human rights in a member state if the Security Council under Article 39 first determines that the civil war or the violation of human rights poses a threat to international peace and security. Intervention under League of Nations and United Nations and the concept of domestic jurisdiction. Article 27 of the United Nations Charter provides nothing contained in the present charter authorizes the United Nations to intervene in matters which are essentially within the domestic jurisdiction of any state. According to Professor Quincy Wright, it is clear that the obligation which arise from the implementation of the provisions of Charter are matters which are not within the domestic jurisdictions of any state. Article 27 has made it clear that the prohibition regarding non-intervention by the United Nations in the domestic jurisdiction of any state will not apply to the Security Council when it takes any enforcement or preventive action against any state or the maintenance of international peace and security. Comparison with League of Nations. Article 15 of the Covenant of the League of Nations was to a great extent similar to Article 27 of the United Nations Charter, Article 15 of the Covenant of the League of Nations provided that the League of Nations could not intervene in matters which were solely within the domestic jurisdiction of the states. Professor Julius Stone has pointed out the following differences in the League provisions and the provisions of the United Nations Charter. Under the League of Nations, the League Council had to decide whether a matter was within the domestic jurisdiction of a state or not. There is no such provision in the United Nations Charter, according to Professor Kelson. This will mean that under the United Nations Charter, each state is free to determine whether a particular matter is within its domestic jurisdiction or not. Professor Julius Stone does not agree with this view. In this view, each organ of the United Nations before which the matter arises is entitled to determine whether a particular matter is within the domestic jurisdiction of a state or not. Under the League of Nations, any state which claimed that a particular matter was within its domestic jurisdiction had to prove it. There is no clear provision in this connection in the United Nations Charter. Under the League of Nations, a matter could be within the domestic jurisdiction of a state if it was not covered by international law. Under Article 27 of the United Nations Charter, it is not necessary. Thus, the provisions of the Covenant of League of Nations and the United Nations Charter are different as regards the words a matter which by international law is solely within the domestic jurisdiction of a state. Professor Bradley has expressed the view that no matter which is regulated by international law can be a matter which can be a matter within the domestic jurisdiction of a state. Thus, it is clear that United Nations cannot intervene in domestic jurisdiction of any state. But what their matters would be was not settled once and for all in advance. This was left to be decided pragmatically in the practice of the United Nations on a pursuit of the historical perspectives, debates, and conferences. It is clear that the representatives of the state in San Francisco Conference intended that the United Nations should neither discuss nor pass any resolution in regard to matters which were which are within the domestic jurisdiction of any state. However, this conception has undergone significant changes. It is now well recognized that the discussions in the United Nations and the passing resolution to implement the provisions of the Charter do not amount to intervention in the domestic affairs of any state. Inclusion of any matter in the agenda of General Assembly, discussion on it, its study, or the passing of a general resolution would not amount to intervention. Famous Indian jurist M.S. Rajan has also made it clear in this book that the resolutions of the General Assembly, which are passed to fulfill international obligations of members, are within the jurisdiction of the United Nations. As pointed out, the United Nations is empowered to intervene in civil wars of states. Examples of Congo and Cyprus may be cited in this connection. In his view, when the civil war reaches a stage which endangers international peace and security, it becomes necessary for the United Nations to take necessary collective action. कैबिनेट ने जयपुर मेट्रो प्रोजेक्ट फेज 2 को दी मंजूरी। असम, केरल और पुदुचेरी की 296 विधानसभा सीटों पर थोड़ी देर में वोटिंग। असम, केरल और पुदुचेरी में एक ही चरण में मतदान। विदेश मंत्री डॉक्टर जयशंकर आज से मॉरिशस और यूएई के 4 दिवसीय दौरे पर। विदेश मंत्री मॉरिशस में हिंद महासागर सम्मेलन में होंगे शामिल। पश्चिम बंगाल में आज पीएम मोदी पीएम की अध्यक्षता में हुई कैबिनेट बैठक के लिए 5 बड़े फैसले। लगभग 2.25 लाख करोड़ रुपए के मेगा प्रोजेक्ट्स को हरी झंडी। खरीफ सीजन के लिए पोषक तत्व आधारित सब्सिडी। कैबिनेट ने जयपुर मेट्रो प्रोजेक्ट फेज 2 को दी मंजूरी। असम, केरलम और पुदुचेरी की 296 विधानसभा सीटों पर थोड़ी देर में वोटिंग होगी। असम, केरल, पुदुचेरी में एक ही चरण में मतदान। विदेश मंत्री डॉक्टर जयशंकर आज से मॉरिशस और यूएई के दौरे पर। विदेश मंत्री मॉरिशस में हिंद महासागर सम्मेलन में होंगे शामिल। पश्चिम बंगाल में आज पीएम मोदी की 3 जनसभाएं। पीएम की अध्यक्षता में हुई कैबिनेट बैठक में लिए गए 5 बड़े फैसले। लगभग 2.25 लाख रुपए के मेगा प्रोजेक्ट्स को हरी झंडी। खरीफ सीजन के लिए पोषक तत्व आधारित सब्सिडी को मंजूरी। कैबिनेट ने जयपुर मेट्रो प्रोजेक्ट्स फेज 2 को दी मंजूरी। असम, केरल, पुदुचेरी में विधानसभा सीटों पर थोड़ी देर में चुनाव। असम, केरल, पुदुचेरी में एक ही चरण में मतदान। विदेश मंत्री डॉक्टर जयशंकर आज से मॉरिशस और यूएई के 4 दिवसीय दौरे पर। विदेश मंत्री मॉरिशस, हिंद महासागर। पश्चिम बंगाल में आज पीएम मोदी की 3 जनसभाएं। पीएम ने देश को याद दिलाई अपनी सौगंध। पीएम की अध्यक्षता में हुई बैठक, कैबिनेट बैठक। लगभग 2.25 लाख करोड़ रुपए के मेगा प्रोजेक्ट्स को हरी झंडी। खरीफ सीजन के लिए पोषक तत्व। कैबिनेट ने जयपुर मेट्रो प्रोजेक्ट फेज 2 को दी मंजूरी। भारत का स्टील उत्पादन वित्त वर्ष 26 में 10.7 बढ़ा। असम, केरल, पुदुचेरी की 296 विधानसभा सीटों पर थोड़ी देर में वोटिंग। असम, केरल, पुदुचेरी में एक ही चरण में मतदान। जयशंकर आज मॉरिशस और यूएई के दौरे पर। under the League of Nations. The League Council had to decide whether a matter was within the domestic jurisdiction of a state or not. There is no such provision in the United Nations Charter. According to Professor Kelson, this will mean that under the United Nations Charter, each state is free to determine whether a particular matter is within its domestic jurisdiction or not. Professor Julius Stone does not agree with this view. In his view, each organ of the United Nations before which the matter arises is entitled to determine whether a particular matter is within the domestic jurisdiction of a state or not. Under the League of Nations, any state which claimed that a particular matter was within its domestic jurisdiction had to prove it. There is no clear provision in this connection in the United Nations Charter. Under the League of Nations, a matter could be within the domestic jurisdiction of a state if it was not covered by international law. Under Article 2.7 of the United Nations Charter, it is not necessary. पीएम की अध्यक्षता में हुई कैबिनेट बैठक में लिए गए 5 बड़े फैसले। भारतीय नौसेना प्रमुख प्रशिक्षण स्पेशल पद, खरीफ सीजन के लिए पोषक तत्व आधारित सब्सिडी को मंजूरी। कैबिनेट ने जयपुर मेट्रो प्रोजेक्ट फेज को दी मंजूरी। भारत का स्टील वित्त वर्ष 26 में 10.7% बढ़ा। एशियाई कुश्ती चैंपियनशिप में भारत ने जीते 3 और पदक। आईपीएल में आज कोलकाता नाइट राइडर्स का सामना लखनऊ में। असम, केरल और पुदुचेरी की 296 विधानसभा सीटों पर थोड़ी देर में चुनाव। असम, केरल, पुदुचेरी में एक ही चरण में मतदान। विदेश मंत्री डॉक्टर जयशंकर आज से मॉरिशस और यूएई के 4 दिवसीय दौरे पर। विदेश मंत्री मॉरिशस में हिंद महासागर सम्मेलन में शामिल होंगे। पश्चिम बंगाल में आज पीएम मोदी की 3 जनसभाएं। आसनसोल और सूरी में रैली करेंगे पीएम मोदी। पीएम की अध्यक्षता में हुई कैबिनेट बैठक में लिए गए 5 बड़े फैसले। लगभग 2.25 लाख करोड़ रुपए के मेगा प्रोजेक्ट्स, खरीफ सीजन के लिए पोषक तत्व आधारित सब्सिडी को मंजूरी। कैबिनेट ने जयपुर मेट्रो प्रोजेक्ट फेज 2 को दी मंजूरी। Thus, the provisions of the Covenant of League of Nations and the United Nations Charter are different. As regards the words a matter which by international law is solely within the domestic jurisdiction of a state, Professor Brierley has expressed the view that no matter which is regulated by international law can be a matter within the domestic jurisdiction of a state. Thus, it is clear that United Nations cannot intervene in domestic jurisdiction of any state, but what these matters would be was not settled once and for all in advance. This was left to be decided pragmatically in the practice of the United Nations on a parcel of the historical perspectives, debates and conferences. It is clear that the representatives of the states in San Francisco Conference intended that the United Nations should neither discuss nor pass any resolution in regard to matters which are within the domestic jurisdiction of any state. However, this conception has undergone significant changes. It is now well recognized that the discussions in the United Nations and the passing resolution to implement the provisions of the Charter do not amount to intervention in the domestic affairs of any state. inclusion of any matters in the agenda of General Assembly, discussion on its study, or the passing of a general resolution would not amount to intervention. Famous Indian jurist M.S. Rajan has also made it clear in his book that the resolution of the General Assembly, which are passed to fulfill international obligations of members, are within the jurisdiction of the United Nations. As pointed out above, the United Nations is empowered to intervene in civil wars of states. Examples of Congo and Cyprus may be cited in this connection. In his view, when the civil wars reach a stage which endangers international peace and security, it becomes necessary for the United Nations to take necessary collective action. Legitimacy of the use of force against economic coercion, example of Bangladesh. It is generally and universally recognized that human rights were openly violated in Bangladesh in 1971. Even after the elections, the elected representatives of the people were not allowed to form their government. The violation of human rights in Bangladesh reached such a magnitude that it ceased to be a matter within the domestic jurisdiction of a state and became an international matter. In the view of Dr. Alam Singhvi, the influx of lakhs of refugees to India endangered international peace. Besides this, the crime of genocide, which was perpetrated, was an international crime and did not come within the domestic jurisdiction of any state. The Genocide Convention is the expression of the words conscience through law and makes it plain by affirming that crimes referred to in Article 2 and 3 third thereof are a matter of international concern and so outside the matters essentially within the domestic jurisdiction of any state of Article 2, Paragraph 7 of the United Nations Charter. The United Nations could intervene in Bangladesh on humanitarian grounds for the genocide committed and atrocities caused by Pakistan armed forces were clear violation of human rights and posed a grave threat to peace. It must, however, be noted that the UN could intervene only if the Security Council determined under Article 39 that the situation there posed a threat to the international peace and security. But under the Charter, no state can intervene in the affairs of another state on the ground of violation of human rights. But it has pointed out that yes, the essence of aggression is that a state poses a threat to the socio-political fabric of another state. All the underlying idea of individual self-defense is that if a state's fabric is threatened by another state, it has a right to take all the steps it may deem necessary to terminate that threat to protect itself. An obvious corollary to this is that a state's right of self-defense is not confined to cases of armed attack only. It was alleged by Pakistan that Indian armed forces went in action in 21st November 1971 and from 3rd December they were collaborating with the guerrillas of Bangladesh. The Indian representative in the UN admitted that India took military initiative on 21st November 1971, but he added that it should not be looked at in isolation from other events which had occurred and were occurring. The influx of refugees continued and it endangered India's political life, as pointed Mishra. Civil aggression as it took place in India is excluded from the concept of aggression. Once this is accepted, it logically allows the victim of aggression the right of self-defense. This is the only jurisdiction which one can give in favor of India's action. The provisions of the Charter as they stand at present do not permit such type. आईपीएल में आज कोलकाता नाइट राइडर्स का सामना लखनऊ सुपर जायंट्स में। 833 उम्मीदवार। भारत यूएस व्यापार पोर्टल लॉन्च। व्यापार को मिशन 500 तक पहुंचाने की दिशा में अहम कदम। पुदुचेरी विधानसभा चुनाव। असम, केरलम और पुदुचेरी की 296 विधानसभा सीटों पर चुनाव आज। 30 सीटों पर मतदान, एक ही चरण में मतदान। It has been pointed out a large number of the third world and socialist states have taken the view that the term force must be construed as to include not only physical or armed force but also all forms of coercion, including those of economic, political and other character. Further, overwhelming majority of states now subscribe to the view that economic and other forms of coercion are violative of the principle of non-intervention. The situation with which India was confronted was unprecedented, and if India had not taken the said action, probably it would have become impossible to ensure the return of the refugees. The framers of the Charter probably never envisaged such a situation. The UN Charter should therefore be suitably amended to cover such situations. It would not be wrong to say that India's action has already modified thinking of the international community in this respect. The General Assembly on 18 November 1987 adopted a declaration on the enhancement of the effectiveness of the principle of refraining from the threat or use of force in international relations. In this declaration, the General Assembly solemnly declared states have the duty to abstain from armed intervention and all other forms of interference or attempted threats against the personality of the state or against its political, economic, and cultural elements. I thank all my brothers and sisters, ladies and gentlemen, students, scholar, teacher, trainer, professor, professional, officer, official, listener, learners. I thank all respected doctors and directors. I thank all honorable advocates, attorneys, Mr. Advisors. I thank all honorable minister managers. I thank the most honorable President, Prime Minister Modi ji. Thank you very much. Nice to see all of you. Thank you. Good morning, everybody. Good morning. Thank you.